All right, crazy kids, I'm here without the pups. We're going to do the Eighth Amendment lecture. The Eighth Amendment, as you need to learn it, is all about the death penalty. That will be the focus of the Eighth Amendment ban on cruel and unusual punishment. It has been incorporated against the states, as this lesson will show. So in Google Classroom, you'll see this document that I've posted. Go and take a look at it. It's an interesting document. It's put out by an advocacy group against the death penalty. So some of the information, look, the number of people executed, the percentage of people on death row by race, all those are just plain old statistics. There's some reports in here, recent studies on race. I don't know, maybe they're, I imagine they're probably valid studies, so they may not be the only ones. Just understand, with all information, you have to know who the source is and evaluate it on that. But take a couple minutes to read through this report. It's pretty interesting. And then, so pause this right now and read through it, and then I'm going to be making some references to it as the lesson goes on. So have it handy. All right? Okay, so pause and do that. All right, death penalty lecture. Question: if you were going to be executed, what would your last meal be? Mine, personally, would be like 5 giant bean burritos. It would be my last great act of defiance. You know what happens when you die, right? Okay. Do you believe in the death penalty? Think about that, discuss that with your friends. Okay, there are a couple of videos. I have posted these on Google Classrooms. They are interesting to watch. This is a video that discusses the last execution that happened in Arizona. It was a problem execution because of the lethal injection didn't work well or correctly. And then here's a video on possible challenges to the lethal injection as cruel and unusual punishment. I think people who are against the death penalty are playing with fire, because if the death penalty was, if lethal injection was ruled unconstitutional, states could go back to their regular techniques. By the way, Arizona, until 1992, I believe, executed people in the gas chamber. Okay, why have the death penalty? Look, this is not going to be on the AP exam, but it's something to think about. 3 main justifications. The main one, an eye for an eye, a tooth for a tooth. Are there some people that do things so horrible that they just should be put to death? There was a guy in Norway who set off a bomb. He was a anti-Muslim guy, set off a bomb in Oslo, killing 9 people, and then took a motorboat out to an island where there were hundreds of high school students at a camp, and shot 60 some of them, and he got 20 years in prison, the maximum punishment under Norwegian law. Retribution, an eye for an eye. Deterrence. Deterrence is what? Deterrence is sending a message to other people. Hey, don't commit murder or you will be put to death. It's an interesting, you can take a look on page 3 of the death penalty fact sheet. They have some information on deterrence. Deterrence is interesting with respect to the death penalty, if you think about it, though, because you have to think about, are there a group of people that say, I'm willing to risk life imprisonment without parole, but I'm not willing to risk being put to death? To me, that sounds like a very thin slice of people. A lot of people say just execute people because it will save money over keeping them in prison for the rest of their lives. I will tell you, as a lawyer that practiced criminal defense, the information on page 4 of the death penalty fact sheet on financial facts rings true to me. If you have more questions on that, you can ask me. Take a moment, pause the video, and read on the top of page 4 those recent studies on the financial impact of the death penalty. All right, you back? Okay. The main thing, the big controversy on the Eighth Amendment ban on cruel and unusual punishment is that it is applying it to the death penalty. What about the death penalty? Now, there is a problem with arguing the death penalty constitutes cruel and unusual punishment. What is the problem with arguing the death penalty constitutes cruel and unusual punishment? Well, if you are somebody that interprets the Constitution by original intent, can you argue the death penalty is inherently cruel and unusual punishment? And the problem is, what were they doing to people back then? They were executing them. So it's a hard argument to argue that the death penalty in and of itself constitutes cruel and unusual punishment. By the way, here's a picture of Mr. Parker, the last person that was hung in the Prescott County Courthouse. He robbed a bank and then killed the guard while trying to escape from jail. Nice suit, huh? Okay, but there was a problem. There was a problem both within states and between states. It was just willy-nilly who got and who did not get the death penalty. Somebody would get a death penalty and somebody else would get 20 years depending on the judge. There was no consistency. It was irrational. The application of the death penalty was irrational. So in Furman v. Georgia, this is not a required case. You don't have to remember it. But it's cool just in life to understand what it said. I don't think it'll ever come up on the AP exam, but it might. In Furman v. Georgia, the Supreme Court said that Georgia and Texas's death penalty laws were unconstitutional as they were being applied because the results were irrational. They didn't make any sense. So they didn't strike down the death penalty as inherently unconstitutional. They said it was being applied in an unconstitutional manner. In Furman, the Supreme Court said you can't just give somebody the death penalty. You have to give, in addition, after finding them guilty, you must also prove aggravating circumstances. And you must have a jury balance those aggravating circumstances against mitigating circumstances and have a jury decide whether to impose death or not. This is an AP issue because of the issue of precedent. So even though Furman v. Georgia only struck down Texas's and Georgia's death penalty statutes, no state statute in America, no state's statute complied with the rules imposed by Furman v. Georgia. So, because Furman v. Georgia was binding precedent, meaning it governed the entire law of the land, the Supremacy Clause, right? The Supreme Court has the final say on what the Constitution means. So, in effect, it struck down every state's death penalty statute. Does that make sense? 35 states subsequently passed laws, repassed death penalty laws in compliance with Furman v. Georgia. Now take a look at your death penalty fact sheet on the right margin and see how many states now have the death penalty. And what does that mean? what has happened. By the way, if you look down, you'll see there's an asterisk by New Mexico, which abolished the death penalty, but they didn't make it retroactive. Can you imagine being the guy sitting on death row in New Mexico, and they walk in and they say, hey, I've got some good news and some bad news. What do you want first? And he says, well, I'm an optimist. I want the good news. And they say, well, the death penalty has been abolished in New Mexico. And he says, great, what's the bad news? And they say, they didn't make it retroactive. You're going to be the last person to die in New Mexico. Lovely. Okay, now, this following information on Arizona will not be on the AP exam, but it's interesting, and so get educated. Supreme Court has said you only get the death penalty for first-degree murder. I guess that could be on the AP exam. Under Arizona law, there are 3 ways to commit first-degree murder. Murder by premeditation, felony murder, or murder of a police officer on duty. If you want to see something scary, go to this statute, ARS 13-1105. I don't think this link opens. You'll have to copy it and paste it into Google. And read paragraph 2, which basically says if you commit any one of those offenses and somebody gets killed in the process, then you are guilty of first-degree murder. You and a friend drive to a bank to rob the bank. You say to your friend, hey, no guns, no weapons, right? I'm going to be the getaway driver. You're going to go in. You don't have a gun. Your friend lies to you, goes in, shoots the guard, comes out. Guess what? You, as the getaway driver, are guilty of first-degree murder. Read it carefully. It says while fleeing a crime. So you two drive off from a bank robbery and you get into a crash and kill somebody. Guess what? First-degree felony murder. This is Arizona's law on premeditation. Interesting. We have a debate, and if we had a class on what would constitute premeditation, any length of time to permit reflection. What does that mean? By the way, what is this language? It's not premeditation if done with the instant effect of a sudden quarrel or heat of passion. So you're married and you walk into your spouse in bed with somebody and you kill them. Is that not first-degree murder? Arizona has aggravating and mitigating circumstances. I've highlighted in red some of the more interesting ones. I'll let you read those on your own. This basically multiple offenders, if you hire somebody or you get hired to kill somebody. One of my personal favorites, cruel and heinous and depraved. So you kill somebody and then chop their body into pieces, first-degree murder? No, they were already dead. They were already dead. I think this one's insane. You belong to a street gang and you commit a crime, first-degree murder. And this one's weird. Thrill kill? Hey, I think it'd be neat to see what it feels like to kill somebody. By the way, under Arizona law, if you kill an unborn child in the womb. So, boys, you hear your girlfriend is pregnant and you punch her in the stomach to get her to miscarry, and she miscarries, guess what? You have committed first-degree murder under Arizona law. All right, here's the mitigation. Now understand, these are mitigating circumstances where you are arguing to the jury to not give the death penalty. Somebody's already been found guilty. These are not defenses. These are arguments that you would give to the jury to ask for mercy and not give the death penalty. So take a minute and read those. If you have any questions, text me. Take a look at pages 1 and 2 of the death penalty fact sheet. This is an area of concern. Remember, 14% of our country's population is African American. Look at the percentage of defendants executed and defendants on death row. And you will see there is a gross disparity between the blacks as a percentage of our population and people in on death row, and blacks on death row. Read at the top of paragraph on page 2 of the death penalty fact sheet, those studies on race. Do those sound like they ring true? This was addressed by the Supreme Court in a 1987 case called Kemp. In Kemp, the plaintiff argued that, hey, he showed statistics. If I'm a black guy, especially if I'm a black guy that killed somebody white, I'm going to get the death penalty at a much higher percentage than if I was a white guy. The Supreme Court, by a 5-4 vote, said that those statistics weren't enough without evidence of purposeful discrimination. Interesting. If this vote would have gone the other way, I think the death penalty would have been abolished, because I don't see any way to fix this. Do you? Is there any way to keep a jury from taking race unconsciously into account? Recent Supreme Court cases. Supreme Court in 2002 said it is cruel and unusual punishment to execute somebody who is mentally retarded. Don't get mad at me, that's their language, not mine. I think it has to do with a IQ test under 70 or something. Tragically, since 1976, no, I'm sorry, excuse me. In Roper, 2005, the Supreme Court said it is a cruel and unusual punishment to execute somebody who was a juvenile at the time the crime was committed. So a 16, 17-year-old, 15-year-old, 14-year-old killing somebody can no longer be put to death. Bummer for these people. From 1976 on, after Furman v. Georgia, the new laws were put into effect in compliance with Furman v. Georgia. There were 22 people who killed as juveniles who were executed. Miller, in 2012, the Supreme Court ruled it is cruel and unusual punishment to give somebody who was killed as a juvenile life in prison without parole. Just automatically give them that. You can still give it to them, but you have to go through some analysis, and it shouldn't be automatic. All right, there's Gary Gilmore. If you look on the sheet, I think on page 3, you'll see firing squad is an option. And there's been 3 people executed by firing squad. Those people are all in Utah. Utah allows a prisoner to decide whether to get lethal injection or be shot by firing squad. And this guy, Gary Gilmore said, I want to be shot by firing squad. Every state and the U.S. government uses lethal injection as its principal method. And then I have some information on prisons. A note on prisons. With 5% of the world's population, we have 20% of the world's people incarcerated in jails and in prisons. This is a very interesting, quick CNN video talking about this. I would urge you to watch it. And this link talks about the Dutch taking a different approach on incarceration. And then I have some slides for you to look at talking about that. Okay, now there's a slide missing on my on this version of the PowerPoint. I'm going to put it up near the top that talked about the 8th Amendment is not only cruel and unusual punishment, but also excessive fines. And the excessive fines clause was just, I believe, this year incorporated. I don't think that'll be on the AP test, but it's interesting to show that McDonald versus Chicago was not the most recent time anymore that a Bill of Rights right was incorporated. That was the Second Amendment, but it's been done again in 2020 with the excessive fines clause. So go back and go back to that slide and open the link on the NPR article on that. All right? Thank you, guys.